All right, we're live.
All right, good morning. It is May 7th, and this is Senate Health and Welfare Committee meeting. Today, we're going to be talking about S20 as it has been returned to us from the House Human Services Committee. And committee, just before we ask Katie to go through the bill, I should let you know that I have reached out and talked with folks about what changes have been made in the bill, and that includes Department of Health, because there are a lot of implications for them in the bill. So as we go through the bill, I'll try to share with you some of the thoughts that I might have as a result of reaching out and talking with advocates and administration about the bill. So Katie, thank you for being here. And nothing changed on the House floor, did it?
Correct. Nothing changed on the House floor.
Okay, so the side-by-side that we have from the committee work is still
That's still
intact.
accurate. So I was
All right.
thinking of just pulling that up instead of looking at the actual language of the bill. I think it's sometimes easier to understand the differences with the
Yes.
chart than with the language.
Okay, let's do that.
Okay, I'll go
It's
ahead.
all yours.
Thank you. Okay. And then I have to get rid of the boxes where I can see everybody to see the document. So if you need to interrupt me, you'll have to just shout.
All right. We're good at that.
All right. So this is S20, the PFAS bill. And as you remember, each section, excuse me, dealt with different categories where PFAS or another chemical was in a particular product. So this chart is broken down by section of the bill. So the first section had to do with Class B firefighting foam. And you'll see that we have the as passed Senate, has passed House. So first, in the very first section of that chapter on firefighting foam, we have a definition section. So in terms of changes that the House made, the House removed the definition of department, which was the Department of Health, because most of the places where the department was implicated have been removed in this section of the bill, or in this chapter of the bill. And then there is also a definition added of terminal. So those are two changes. And then we get to language with regard to the prohibition on discharge and use of Class B firefighting foam. And the language that left the Senate said that it would prohibit a person, municipality, or state agency from just discharging or otherwise using for training the Class B firefighting foam containing PFAS. And the House added or testing, use for training or testing. So that's when it's prohibited.
So as we're going through, if you see anything that raises a red flag for you, just please make a note and let Katie know so we can come back and talk about each one. I think today is an opportunity to go through this for the first time. And if we have to come back to it, we will.
Okay. The next section of the bill had to do with a restriction on the manufacture, sale, and distribution. There were a number of changes in this section. So instead of having the very specific exception right here with regard to a certain CFR site, federal regulation site, the House opted for a more general phrasing that unless required under federal law. And then the committee went on to specify that this would be not later than 10/1/23, which is the latter of the two dates specified by the military that they would stop using PFAS in Class B firefighting foam. So that was added at the beginning of subsection A. And then a very specific exception was given for terminals. And so you'll see that language here that although this section, subsection A, takes effect, I believe, July 1, 2022, that this language with regard to terminals would not apply until January 1, 2024. So it gives 2 extra years to come into compliance for terminals. But after that date of January 1, 2024, if a person is operating a terminal and that person seeks to purchase Class B firefighting foam containing intentionally added PFAS for the purpose of fighting emergency Class B fires, that person could apply for an exemption. And they would apply to the Department for Environmental Conservation for a temporary 1-year exemption. And DEC, in consultation with the health department, would grant the application if certain criteria are met. So
Katie,
first,
Katie,
Hmm?
can I just interrupt for a quick, I
Oh,
think
of
I know
course.
the answer to this, but just for clarity's sake, a terminal, do you mean an airport terminal? Or is there something else that would be included under the term terminal?
It's a bulk gasoline terminal, and I'm trying to grab
It's
my
like a
specific
fuel terminal,
language.
isn't it? Is it like a fuel terminal place where you,
Let me grab the specific definition so I can let you know how it's defined in the bill. Terminal means an establishment primarily engaged in the wholesale distribution of crude petroleum and petroleum products, including liquefied petroleum gas from bulk liquid storage facilities.
And do you have a sense of how many there are in the state?
My recollection from Human Services, and again, I am not always in the room, and I did miss the testimony from the person operating a terminal who spoke, but very few. I would clarify either with the reporter of Human Services, but I don't want to hazard a guess, but it was few, single digits.
Okay.
Okay. So with regard to the criteria that has to be met to get the exemption, the first is clear and convincing evidence that there is not a commercially available alternative that does not contain intentionally added PFAS and is capable of suppressing large atmospheric tank fire or emergency Class B fire. Second, providing information on the amount of Class B foam containing intentionally added PFAS that is annually stored, used, or released at the terminal. Second, a report on the progress being made by the applicant to transition at the terminal to a Class B foam that does not contain intentionally added PFAS. And lastly, an explanation of the containment plan and containment measures at the terminal. And then there's
Katie?
Yes.
The extension for those terminals, is that a one-time extension?
It's a one-time extension. So again, this restriction as it applies to terminals would take effect two years later. And on top of that, if the terminal is to provide an application with all of this information and it's accepted by DEC in consultation with the health department, they get one extra 1-year exemption. And then there's new language that says this carve out for terminals does not prohibit a terminal from providing Class B foam in the form of aid to another terminal in the event of a Class B fire. And then we have a section in this chapter on PPE, and the House version is the same as the Senate, with the exception that the House version removes the requirement that the health department may request that the person, manufacturer, purchaser furnish the notice required under this section. If you remember, the Senate version or both versions require that the person that sells the equipment and the person or municipality or agency purchasing the equipment that has PFAS, that there is a notice that is kept by both parties. And the Senate version says that the department can request to see that notice. So that is the language that has been removed in the Senate version. Next, there's language on notification and recall. The first subsection in this section, subsection A, is the same, and that requires that the manufacturer of a prohibited firefighting foam is to notify persons that sell the products in Vermont about the provisions of the chapter not less than 1 year after the effective date. And then there's language, and I was trying to show you that some of the Senate language was retained, but there could be additional House language. So as you might imagine, where this language is underlined, that is new added language by the House. So the House added, unless for use at a terminal prior to when the previous section applies to terminals. So this is just kind of a carve out, recognizing that there are different rules for terminals. And then the same language that the Senate had: a manufacturer that produces, sells, or distributes Class B firefighting foam containing intentionally added PFAS shall recall the product and reimburse the retailer or any other purchaser for the product. And then the new language is an issue either a press release or notice on the manufacturer's website describing the product recall and reimbursement. So this is a public notice piece. It's not just about notifying the purchaser. This language includes that the manufacturer is also issuing some type of public announcement through either a press release or through a statement on the website of the manufacturer. The next piece is the certificate of compliance. This has changed a bit. When it left the Senate, the Department of Health was really responsible for this piece. And I don't know if you recollect what the certificate of compliance piece was, but it allowed the health department to request a certificate from the manufacturer of foam or PPE that attests to the manufacturer's compliance with the chapter. And then the department was required to assist other state agencies to avoid purchasing or using prohibited foams. And the department was to assist other state agencies, town fire districts, and other municipalities, and to give priority and preference to the purchase of PPE that does not contain PFAS. So the new version that came over from the House authorizes the Attorney General, not the Health Department, to request a certificate of compliance from the manufacturer. And within 30 days of the request, the manufacturer shall either do one of the following. It shall either provide the AG with a certificate attesting to the manufacturer's compliance with the chapter, or if the manufacturer finds that they're not in compliance, notify persons who are selling a product of the manufacturers in Vermont that the sale is prohibited because the product does not comply with the chapter, and then submit to the Attorney General a list of the names and addresses of those persons who are notified under this subdivision. And then next we have a penalty section. And this language that left the Senate, a violation of the chapter is considered a violation of the Consumer Protection Act. That all stayed in the bill. So this language, subsection A, is the same. That just means this has been retained in the House version. What's been added is a clause that this section shall not be construed to preclude or supplant any other statutory or common law remedies. So meaning a violation of this chapter is not the only, is subject to possibly other penalties, not just the Consumer Protection Act. And one thing to note here is when the bill left the Senate, the only penalty language was in this chapter on firefighting foams. So the House has repeated this language for nearly every chapter of the bill. So you'll see this repeated throughout. And the same thing is true with the certificate of compliance language, that this language with the AG being able to make a request as to whether there is compliance, that this identical language is repeated in each chapter of the bill that's being created. So you'll see that again. Next, I'm going to transition from firefighting foams. The next section of the bill had to do with food packaging, and it was broader than just PFAS. PFAS were addressed in one of the sections of the bill, but phthalates and bisphenols were also addressed in this section of the bill. So first, with regard to definitions, there were some amendments to the definition sections. So the definition of food packaging has changed. So first, it uses the term food package or food packaging because they're used interchangeably in this section, means a package or packaging component that is intended for direct food contact. And you'll see here that the version that left the Senate was a longer definition. So you'll see that this language, oh, I can't highlight. this language is what was removed from the Senate version. Phthalates was replaced with orthophthalates to mean any member of the class of organic chemicals that are esters of a phthalic acid containing 2 carbon chains located in the ortho position. And then packaging component was had an addition to it, and that is disposable gloves used in commercial or institutional food service that had been previously part of the definition of food package. And when some of the language was removed from food package, it was moved to packaging component. So you'll see.
Sorry.
Nope, go ahead.
I was just going to talk about orthophthalates. That the suggestion for that change is really related to the definition that Maine uses. And I think also, and then the packaging was related to what New York and Washington use. And Dr. Vos from the Department of Health supported the orthophthalate designation, which is fine. It very much relates to what we did, but it's just slightly different.
Okay. So the first, the next section of the bill is divided into a few different subsections that each deal with a different chemical. So subsection A dealt with PFAS. And you'll see that the House and the Senate version are nearly identical, with the exception that the House added this language "and are present." So it prohibits a manufacturer, supplier, distributor from manufacturing, selling, or offering for sale, distributing for sale, or distributing for use a food package to which PFAS has been intentionally added and are present in any amount. So that is the addition in subsection A. Subsection B pertains to bisphenols in food packaging, and there have been more changes here. So you'll see, to begin with, the language is very similar, with the exception that the same language "and are present" has been added to the first sentence in this section. So we have, this was a rulemaking provision. This wasn't a straight out prohibition on use. So both the Senate and House version allow the Department of Health to adopt rules prohibiting the manufacturer, supplier, distributor from selling or offering for sale or for promotional distribution a food package or the packaging component of a food package to which bisphenols have been intentionally added and are present in any amount other than incidental presence. And then there's language added on the House version that the department may exempt specific chemicals within the bisphenol class when clear and convincing evidence suggests that they're not endocrine active or otherwise toxic. So while the Senate version applied to rulemaking for all bisphenols, this is saying that the rulemaking, there could be a carve out or an exemption for those bisphenols, those chemicals within the class that are not known to be endocrine active or otherwise toxic. The structure of these two sections are different, but you'll see there's a lot of language that has been retained from the Senate, even though it's sort of structurally organized different. So next, in this bisphenol section, the Department of Health may prohibit a manufacturer, supplier, distributor from selling or offering for sale or for promotional distribution a food package or the packaging component of a food package if the department or another state has determined that a safer alternative is readily available in sufficient quantity and at comparable cost and is a safer alternative and performs as well or better as bisphenols in a specific application to a food component. So this concept has all been retained from the Senate with the exception of this language "or another state." So it's not just the department that has to make a determination. If another state has made that determination, the department can rely on that. And then there's this language that the department prohibits a manufacturer, supplier, distributor from selling, offering for sale, or promotional distribution of food package or packaging component of a food package, and that the prohibition is not to take effect until 2 years And then the Senate had language after the department determines a safer alternative is available. That language was struck because it's not necessarily the department making that determination. It could be the department is relying on another state. So that language has been removed. The next subsection in the section transitions from to phthalates. And here you'll see the Senate version use the term phthalates. Of course, we just went over the definitions, changing that term to orthophthalates. And the two sections are very similar, with the exception that that language addition that we've seen in the previous two sections have been intentionally added and are present in any amount has also been added here by the House. This language, that the section shall not apply to the sale or resale of used products, has been retained in the House version. And then we have the certificate of compliance. I won't go through this in detail again because it's the exact same as the language in the firefighting foam, but it is the AG has this authority versus the health department as in the Senate version. The rulemaking authority is in the House version is the same as it was in the Senate version. And then, as I noted above, only the firefighting foam had a penalty section that has been changed. There's now a penalty section in every new chapter created by this bill. And so this penalty language is the same as the language we just went over with regard to the firefighting foam.
Okay.
So that is the food packaging section. Next
Before we
is,
go on, could I ask a question? And maybe this is directed at Senator Lyons, but to put in "and are present," intentionally added "and are present." Can you just speak to that for a second? I mean, do these things dissipate? What happens?
It could, and that's kind of what we heard from the Sherwin-Williams paint folks. So that might be a transitory substance. It might be added intentionally, but then in the manufacturing process, it goes away. It leaches out or disappears.
Okay.
Yeah, that's all.
Just thank you for that clarification.
Yeah, thank you.
okay. So moving to section 3, which was the rugs and carpets and the aftermarket stain resistance. So the prohibition in the first section of that chapter is the same. That language has not changed. What has changed again is the certificate of compliance, and it is consistent with the language that you've seen so far, moving it from the health department to the AG. Rulemaking is the same in both the House and Senate versions. And of course, the penalty language has been added here as well in the rugs and carpets and aftermarket stain and water resistant chapter.
Katie, can I ask a question?
Please.
So the certificate of compliance is required, comes from the AG's office, but is that?
I wouldn't
to
say
request, the AG can request it from the manufacturer.
Yes. Mm-hmm.
But the rulemaking, remains with the Department of Health. Is there
Yes.
any other role for the AG besides just potentially requesting that certificate?
I believe that's it. I mean,
Okay.
enforcement. So
Enforcement,
penalties.
okay.
Yeah.
Of course. All right.
Yeah,
So
so-
I'm trying to figure out, I mean, it's hard to, I can look at the actual language, not just is there a disconnect between who is doing the work and who's making the rules? Or is it just looks like it because it's on this summary? You know what I mean?
Well, there's not really other requirements in this rugs and carpets chapter for the health department to do anything. They're not really involved in, the prohibition on the manufacturer supplying anything. They're not involved in the certificate of compliance. So to the extent that rules are necessary or guidance is necessary as to what this prohibition is to look like, or what should be in a manufacturer's certificate of compliance that the AG can request, the health department would be the body that's creating rules on this.
Yeah, I guess that's what I'm trying to get at, is that if the AG's office is the one that's enforcing it and potentially asking for compliance, then does it make sense to have the health department making the rules?
Well, the rules are maybe slightly different in each area. So the rules about which chemicals and which products would be within the Department of Health. But the rules about the certificate of compliance would go through the Consumer Protection Division in the AG's office. And so they do this quite frequently in other areas. So, but it's probably worth, Katie, if you don't mind, reaching out just to clarify that, that would be helpful.
Sure. What I was just looking at the language of the bill itself, to see if it was a shall or may, just to make sure that was captured correctly in the section by section, but it is a shall, so it's not up to the health department's discretion. It is requiring the health department to adopt these rules that would govern the prohibition. It doesn't specify, though, exactly what the rulemaking would be on. They shall adopt any rules necessary. So there is a little bit of leeway there. Any rules necessary. I guess if they didn't deem that any rules were necessary, they wouldn't have to adopt any. But for the implementation, administration, and enforcement of the chapter. So it's not specific to say, you know, you have to say what's going to be in the certificate of compliance, or you have to adopt rules on what this prohibition piece would look like, or how, you know, it leaves a lot up to the discretion of the department.
Yeah, I guess I'm just, you know, if the AG's office is enforcing it and asking for the certificate, maybe they should be making the rules, but
Well,
it's just something to flag, because it seems to be a disconnect.
Okay.
So the AG's office would not make the rules about the specific amount of substance or the type of substance or the consumer product. So I think that's what we're talking about here. So for the Department of Health, they're going to be making rules about how much PFAS is in the product, or on the rug, or not on the rug. And the AG's office is making rules about when the certificate is required, based on, I would very much think, based on the Department of Health rules and guidelines. This is not different from other areas of consumer product enforcement. But again, I think, Katie, if you can reach out and bring us back, there may be some language that would help clarify this, but it may not be necessary. We'll just see.
Sure, I'm happy to
good
reach out.
question.
Are you looking for me to reach out to the health department or the AG, or both?
I would think both.
Okay.
I think David Englander, I have talked with David a little bit about this, and he was convincing and agreeable. And I think talking with AG's office would also be helpful.
Okay. So I think that brings us to the end of this section. And then
And
we
Katie,
are,
sorry, just to be clear, I think that applies to all the sections, because the rulemaking and enforcement and stuff is true for each of it. It's not just the rugs section.
okay.
So,
But just to clarify, there are places in statute across the board for different things, like possession of something that there might be rules in the Department of Health that is enforced through the Judicial Bureau, or enforced through a certificate process. So I don't want us to get too hung up on it, but I do think it's helpful to understand what the linkages are.
So, Senator Lyons, would it suffice to say in coordination with?
Well, let's find out, let's just see what Katie finds out, and that might be a further proposal of amendment if it looks like it's needed. Yeah, I would agree with that.
Okay. So That brings us to section 4. This is the ski wax chapter. Again, it's very similar to the last section in that the prohibition language is the same as the Senate version. The certificate of compliance language has changed from the health department to having the AG as the authority that can request the certificate. The rulemaking is the same with the Commissioner of Health, and the penalty section that we've seen has been added here. Section 5, so we're sort of transitioning now. So what section 5 does, if you remember, is it amends the section in the chapter on chemicals of high concern to children. There's a list of chemicals of high concern to children, and there's a whole chapter and statute that exists that has a process for adding and removing chemicals of high concern to children, and having manufacturers with children's products that contain these chemicals to provide that information to the health department. So the version that left the Senate had the class of PFAS, all chemicals that fell into the class. The version that is coming back from the House adds 3 PFAS to the previously enacted list versus the whole class. And these are the 3 chemicals that are being added versus the whole class.
So just a comment here that currently PFOA and PFOS are listed by the Department of Health as chemicals of concern. This would add 3 additional chemicals out of a class that is between 3,000 and 6,000 different chemicals. So in conversation with the Department of Health, for them to go through and list all of those chemicals that and the supporting documentation would be extremely difficult. But so having these 3 additional where there is some demonstrated evidence of concern makes sense. So we'll just, this listing does 2 things. One, it extends the number of PFAS chemicals to 5 for chemicals of high concern to children. But it also limits the administrative burden on the Department of Health for listing 3,000 to 6,000 other chemicals. So, it's not, this is, for me, this works, but you may want to add all of the whole class.
I guess I'm just concerned about where they drew the line and would like to understand why it was these 3 and hear testimony about why it was these 3 and not others, given that there are thousands in this class.
So in my conversations with the Department of Health, these are the 3 that have been identified as having significant effect in terms of health effects. So if we need testimony, we can do that. But I think we'll come back to the question. So that's another question we'll add to our list. Go ahead, Katie.
Okay, well, the last section is the effective dates, and that has not changed.
Okay,
So
that's good. All right,
Yeah.
so let's go back through the questions. So Ruth, you had 2 or 3 questions. One was on the last one on the why do we have those 3 and not the 3,000 other ones. And that part of it is utilitarian and part of it is very much linked in with immediate protection. Then the other question is on the rulemaking process between Department of Health and the AG's office, sort of the enforcement section. And I will say this, I do know that manufacturers understand their responsibility about providing information to the AG's office and or to Department of Health. So it's not like this is a new obligation. And then what was the other, was there another question? Senator Hooker, Senator Hardy, do you have another question?
I guess I'd just like to understand a little bit more about the logic behind the whole terminal thing at the beginning, because that's a completely new thing. Like, how many are there? What's the impact of this this provision. I talked a little bit to one of the House members about this, but just having more of a,
Why don't we do
understanding.
this? Why don't we invite the reporter of the bill? I think it's Daniel Whitten. Is it Representative Whitten? Why don't we invite Representative Whitten in to come in and talk with us about the bill? We don't even have it yet, do we? Is it coming over today? It's going to be on the calendar. Is it on our calendar today? I haven't checked.
I haven't checked the
yesterday.
calendar. I think it passed third reading yesterday.
Yeah, so we could meet Tuesday at 9 before floor. Would that, if we can get him in then?
sure. It's on notice, by the way, today.
It's on
the
ours,
Senate-
right?
On
So
the Senate calendar notice.
yeah, so when it comes up for us on Tuesday, we'll have him in on Tuesday, and maybe we can get to some decision or not. So that'll work. So Nellie, 9 o'clock Tuesday, can you please invite Representative Whitten in from House Human Services? Katie, does that work for you that time?
I do have a meeting scheduled at that time. I suspect it may be canceled, so I will likely be able to attend.
Okay, well, we'll keep the meeting, we'll listen, and then hopefully we'll hear something from the AG and DOH on the rulemaking process. I do have one question on the bill. I have a lot of questions on the bill, but after meeting with various folks about the bill, it really, they've done a lot of fine tuning in the bill, and in the particular, the terminal section, which has a lot of implications for different advocacy groups, I think they've done a good job there, and as well as the other parts of the bill. My one question was on the language, use of the language clear and convincing with respect to BPA, and I think it was another place, phthalates. Clear and convincing to me is a legal phrase, and so if we're talking about scientific data, it should be some kind of research based. But looking at the context within which it's used, it doesn't appear to be problematic. So I'm not thinking we have to change it unless we make significant changes elsewhere. I'm fine leaving it. Just wanted to raise that. Was there a discussion about that about that phrase, or?
I don't recollect
Okay.
a specific
We can ask,
conversation about that
I can't
phrasing.
hear you
I'm not
anymore.
always in the room though.
I can't hear you.
Oh,
Hold on. They go out in pairs. So now I have a little brief okay, go ahead, Katie.
oh, I just said that I don't recollect a specific conversation about that phrase, but I am not always in the room when testimony is being taken. So it very well could have happened when I was out of the room.
I'm going to have to speak to the National Guard about their interruption of the state government. Not good. Okay. Any other questions, committee, on S20 and what has come over from the House? Go ahead, Senator Hardy.
So Katie, I'm just scrolling through the language on the bill. The language that they added related to terminals. I see the definition, but what section or page, whatever, is that? The more of the language.
So I'm using, I don't know if our drafts are going to line up. I don't have the official version. I have the version
Section
as
1?
it passed out of Health and Welfare. Not Health and Welfare, Human Services.
I think it's all section 1. Is that your question? I don't know.
I'm just
So
trying to
it's-
find it because it seems to me like that they actually create a bigger carve out for that they allow them to use PFAS for much longer and create a carve
Yeah,
out.
they do. They do.
Yeah.
So it's pages 2 and 3 of my version, but to be more specific, it's 1663. And then it's subsection, well, it's subdivision A2 and then subsection B is the exemption.
Okay, got it. All right, thank you. So yeah, I would just like to hear more about why this is necessary, because it actually weakens the language that we had in terms of the dates.
I'm going to ask you to repeat everything you just
just
said,
sorry.
please. I'm sorry. I can't help it. Not my fault.
No, I'm sorry that you have
Not
to
my
deal with that. I was going to say, I want to understand this more because it weakens what we did. Actually, it provides an exemption and a longer time that these chemicals can be used. And so I'd like to understand more their reasons for why they think that this is necessary.
We'll ask Representative Whitten. Maybe, Katie, do you have the list of questions that we're asking? Can you, I don't want to reproduce them. You can do it better. If you don't mind sending those to Representative, first send them to us collectively, to the committee, and then we'll send them off to Representative Whitten. So in addition to being here to go through the bill with us, those are the more specific questions that we have.
Okay, I'll send the
That
3
would be
questions to the committee.
That'll prep
then
them up a little.
Okay, I'll send the 3 questions to the committee, and
Yeah.
then should I leave it to you to forward it to Representative Whitman, or would you like me to
that's
forward
good.
it?
That's good.
Okay.
Yeah.
And I'll reach out to the health department and the AG about that specific rulemaking question.
Thank you. That's good. And if you, as you're doing that and as you're hearing back for them, if you think it helpful for us to have one or both of them in, we can add them to our list for Tuesday if they're available. Okay, anything else?
I just wanted to know, I have 4 questions written down, Katie. So the rulemaking situation, the PFAS class versus the 3, the terminal language, that whole mishigash, and then the clear and convincing language.
Forget the clear.
That's what I didn't have.
Yeah, forget. I'll ask that, but it's not a significant question.
I'm curious too, though, Ginny. When she brought it up, I'm like, yeah, you're right. It's used multiple times, and it is it.
I will say this. We've been through this discussion when we went through the children's chemicals of high concern. If you go through the bill, look at the context within which it's used in the bill. If it rises to the level of a huge concern, fine. No reason why we can't ask the question. But sometimes it's one of those phrases that sounds good and people put it in, but it doesn't trigger anything until you talk to someone with a scientific background, and then it triggers something. So let's just think about it. All right. Anything else on that? I really, as I go through the bill personally, frankly, and looking at it, I think that the House hasn't done anything that that violates the intent or the activity of the bill, and so I think it's a good place to be. This is not a bad place to be, and I also know that I do believe that this bill is something that the administration can support. So we want to make sure that that stays intact as well. So. Katie, is there anything else we need to know? A lot. We need to know a lot. We're going to download your brain next. All right. Are we good? So we'll meet Tuesday at 9. In the meantime, we'll reach out to Representative Whitten and hope that he is available. If he's not available, we'll change that meeting time. And Katie, you as well. Okay. Just a heads up. Well, I'd like a heads up. I've been communicating yesterday and today with members of House Human Services. And they may have a proposal, a further proposal of amendment coming to us on H-171. So I've been circling the wagons and talking with our Appropriations Committee and others to ensure that any language that comes to us isn't going to create dysfunction. And so we may see that. So if you see it, don't be surprised. So far, so good. It looks like it may be something doable. It is not significantly different from what we had asked for in sections 10, mostly section 10 of H-171. Sections 10 and 11 were the two sections that appropriations changed a lot. So the criteria that we had, or the reaching out to stakeholders that we had wanted, I think we had a working group. And so the working group is gone, but the reaching out to stakeholders has been put in. And that it sounds like a good thing to do when you're making decisions. So just a heads up, so we may see that one. And I don't know what else, except I'm so excited about broadband. Thank you, Senator Cummings. Thank you, Senator Hardy.
It nearly killed us, but we
I
got it done. Oh,
You're muted,
Ann.
Senator. Your T-shirt says I'm muted.
No, we are all appropriately slogged.
Well, we're
It was
going to
hard
try
work.
and not slog us through this. I think be a little forgiving to the House language on S20. I know it's always hard to give up on certain things, but we need to work together. And I think that some of the things that they've done have really been great improvements to the bill. They haven't changed a lot of what we've done. They've just added or modified slightly. So not a bad place to be.
It
All
looks
right.
like S48 is in House Appropriations, the
Yes.
nurse compact
Yeah,
bill.
okay.
Do you know where what's the other one?
22?
Yes.
Yeah, no, I haven't talked about that with Representative Lippert recently, but they were working on it. They're working right now on the task force and other language, the PBM 340B language that's in the budget, trying to get to a good place on that. So we'll see what comes back. And the other thing is, the FDA now is considering banning menthol totally. That would give some maybe impetus to moving our bill S24 and maybe adding PUP to it, purchase, use, and possession provisions. I will again reach out to economic development and see where they are with that. Okay, we're good, I hope.